Morning or good afternoon, depending on where you are. I'm Adolfo Jiménez. I'm chairman of Miami International Arbitration Society. This is our first annual Latin America tour. MIAS was founded 14 years ago, and from its inception, Latin America has been front and center for our organization. Connectivity with the region has fueled our organization and allowed lawyers to work better and work more. And throughout the region, we've worked consistently and brought lawyers together on a consistent basis. Miami and Latin America have become one, and I'm proud to say that MIAS has played an important part. Today, we connect with the region through 6 leading practitioners in the area of international arbitration. Moderating today's program are 2 of our board members, and also leading practitioners on their own. Silvia Marchili, who comes to us via Argentina and Texas, is a partner at White & Case, and joining her is John Rooney, who comes via Louisiana, the Bayou State, and a leading practitioner in his own right, and also a faculty member at the University of Miami Law School. And so I turn the program over to Silvia and John.
Thank you, Adolfo. This is a great pleasure, not only because I'm part of MIAS, but also because we are surrounded by good friends, and I'm sure we'll have a delightful conversation today. To say that Latin America is a dynamic region is probably the greatest understatement, but part of what we want to do and accomplish today is to give you a sense of the latest developments and most critical issues going on in some of the most relevant jurisdictions in the region. A few of the key economies in the region are going through unstable, some may say erratic times, both politically and from an international arbitration perspective. I always say when I start getting a lot of calls from a certain country, I can tell that that something is going on, and that has been the case, at least for me, in particular of Mexico, Peru, and Chile, and those are 3 of the jurisdictions that we're going to take a deeper dive on. Just a couple of housekeeping issues. We will take questions from the audience. If you can write them down in the chat, we will try to address them as we go. And with that, I'll pass the floor to John, who will spend a minute introducing our great speakers today.
Thank you very much, Silvia. And first of all, I'd like to thank each of the speakers for taking time out of their busy schedules to be with us and to share their experience and information with respect to this event. We have representatives of 6 countries, practitioners and academics who are outstanding representatives of their particular jurisdiction. Very quickly, I will go through and note that if you look at the chat function, you will see that there will be specific contact information in the event that you would like to contact any of the speakers and seek additional information. From Mexico, we have Klaus Von Vovisser, a very distinguished practitioner and arbitrator in Mexico, who really, in fact, I think doesn't need much more of an introduction than that. Looking forward very much to his comments. From Colombia, we have Juan Felipe Merezalde, also a very distinguished practitioner based in Bogota, Colombia, who will be bringing us information with respect to what is going on in Colombia. For Central America, Dayala Jiménez, who is with DJ Arbitraje in San Jose, Costa Rica, who will be taking a regional approach with respect to Central America. And for Peru, we have Maria Teresa Quiñones with Quiñones Alaiza in Lima, Peru, And there's been, of course, a lot of activity in Peru, which she will be bringing us up to date with. And for Chile, we have Geraldo Ovalle, who also is a very distinguished and well-known practitioner in the area of international arbitration from Chile, who will be bringing us up to date with respect to developments in that country. And from Brazil, Cristiano de Souza Zanetti, a professor at the University of Sao Paulo, an independent arbitrator also located in the city of Sao Paulo, who will be bringing us up to date with respect to developments in Brazil. So with that, I turn it back to you, Silvia, I guess, and we will begin, I think, by considering Mexico.
That's right. Let's start our tour, the MIAS friends, as we like to describe it. So when thinking about Mexico, it's hard not to think about the recent developments in the energy sector in particular, although the anticipated reforms and existing reforms have been expanding beyond that. But Klaus, you are in a great position to give us an insightful update on what has been going on since last year. It's been over a year since the first measures affecting the power sector were enacted, and of course the anticipated constitutional reform now that will really dismantle the existing regime. It's keeping us, many of us and our clients, quite busy these days. So would you like to start with that, and perhaps we can then take it from there?
Yeah, thank you very much, Silvia. As you all know, Mr. López Obrador, who won the elections 3 years ago, leftist president, I would say more populist than leftist, has been attacking particularly the energy industry. He attacked the prior two administrations, which opened up Mexico to private investment in the energy sector, oil, gas, but as well electricity, and lots of investment have been done in the renewable energies, photovoltaic, windmills, and really electricity, which is very friendly to the environment and has been very successful. Mexico is a big country, has a great climate, and these companies have been tremendously successful, and they have been able to reduce the price of energy in Mexico, favoring industry and favoring the country. The president has taken a different view, and they first started to attack all those companies through administrative measures, which had no legal base, but that were measures that were taken by the government. And of course, all companies repealed those through local decision before Mexican federal courts, and they successfully have been able to stop many of those measures. Then the president sent an initiative to change the energy law. That law was passed, and as well attacked with thousands of amparos, which are constitutional injunctions against those reforms, and those still are pending at different levels of the federal judiciary. But injunctions were issued by judges, so he has not been successful in implementing those changes. And now the last attack or intent of attacking is he sent a bill to Congress in order to promote the constitutional reform in order to overcome all those injunctions that have been filed successfully before the judiciary in Mexico. And now he's trying to obtain the majority or the qualified majority needs in order to pass the constitutional reform. But this morning, we read in the press that the discussion, which was going to take place in Congress at the end of the year, has been proposed to postpone to April. So this is good news. But all those changes have generated massive arbitration, not yet as an investor state level, although there are a few cases I can mention later, but a lot of commercial arbitration because of all the disputes this has generated among shareholders of those companies, among clients with those companies, among bankers that have been financing those projects. So it's massive arbitration, many arbitrations, and it's and we'll see what will happen next. But this is what has been the big change in Mexico, as Silvia is keeping all of us very busy.
Indeed. And from a treaty arbitration perspective, I guess I can help to think about the situation, the crescendo nature, right, of the government's conduct, in the sense that, as you put it, the first tried to go the regulatory way, that didn't work, so they went up to change the law. That seems not to be working, so they went and went for the I guess gold price of changing the constitution itself, which again, and this is my claim, I'm biased, but I think that would make a wonderful section on facts if it ends up as dreadfully as some of us are anticipating. But it's much different. I think that these type of fact pattern are supposed to state that carefully considers its options, is transparent about the changes it wants to implement, and so on. But anyway, we shall see. I guess it's the bottom line there. But as you put it, there's a lot going on already in terms of commercial disputes. And how about the pandemic? Have you seen that have any tangible impact on the arbitration world?
We have not seen that many cases that derive directly from the pandemic. I think we will still see some. I mean, I think there are disputes, but I don't think we have seen yet a lot of cases derived from the pandemic. But because, in my opinion, many of those, although there have been many disputes, a lot of disputes have been settled because I think businessmen have been very conscious of what the pandemic generated, and I think everybody have tried to find solutions. And I think we have seen many settlements to disputes or contracts being renegotiated. And I think we will eventually, there will be a flow of arbitration that will be generated by those disputes. But I don't think we have seen many that have been started yet. I think that I think compared to the energy sector, I think that 90% of the cases have been more in the energy sector, and I would say probably 10% derived indirectly from the pandemic. But at least in Mexico, and in general, I think worldwide, what I've seen in the whole region in Latin America is not that great of a lot of cases derived from the pandemic. At least that's my personal impression. Probably we're so overwhelmed with the energy disputes that I don't think that many derive directly from the pandemic.
Absolutely, and perhaps a quick last question before we switch to another jurisdiction. Any significant developments with respect to court decisions in connection with arbitration, or laws or regulations that would affect the practice?
Not really. I don't think that the arbitration has been under attack. No direct amendments. I think we have had some court decisions from federal courts which are positive to arbitration. I think Mexico has really done very well. The federal court system has been extremely supportive for arbitration. We have seen a few decisions, but nothing. I mean, I think all decisions have been positive, and arbitration has not been under attack, at least by this administration, directly as a way of resolving disputes. So I think arbitration has grown successfully, and even we have had a lot of arbitrations with the state. We had all those commercial arbitrations with the pipelines, the gas pipelines that come from the U.S., which were finally settled. So we had lots of dispute, a lot of dispute with Pemex in terms of collections. The Pemex has a huge debt, so lots of cases are being filed, collection cases against Pemex. Some are settled easily because Pemex wants to pay. I don't think they have the resources, but we've seen more of that. But no attacks on arbitration, at least for the moment being.
I saw somewhere an article that the government was earmarking, I think like 5 times the prior budget for disputes and international disputes. So hopefully that will mean that they will be supportive of.
I think 5 times is little, because if the constitutional reform would pass, I don't think it will pass personally. I think it will not pass, but if it passes, it probably will be the highest number of investor cases worldwide. I think would exceed Argentina, Peru,
Spain,
Ecuador, Spain. I think Spain is nothing compared to what would come because of the size of the country, the size of the investments. I mean, there are companies that have invested more than $10 billion, a single company. So you're talking of hundreds of thousands of millions of dollars. So it would be very, very bad for the country. So I think the budget would have to be increased like by 100 times.
Yeah, yeah.
So,
Agreed.
but hopefully it's not going to happen for my country.
Absolutely, absolutely. So in the interest of time, should we continue our tour? Next
so.
stop, Colombia, John?
I do think so. As I mentioned before, it will be Juan Felipe Melizalde will be giving the presentation with respect to Colombia. And Juan Felipe, if I could just begin by asking, just in a general sense, if there have been any significant developments in Colombia relating to recent developments relating to international arbitration.
Thank you, John. And first of all, I have to thank MIAS and friends for this kind invitation. I also have to apologize. I am the only one who is not wearing a tie. The reason is that I'm traveling and we had a luggage situation. So the good news is that traveling is back. The bad news is that apparently my ties are not. So yes, the answer, John, is there have been many developments in the last 18 months in my country. And let me give you 3 quick updates. The first one is that in July this year, 2021, the Ministry of Justice submitted a bill of law to amend our arbitration statute. As you know, our arbitration statute is a dualist system approved in 2012 that has a domestic chapter and an international chapter. The amendment is mostly for the domestic chapter, but there were some changes in the international one. I'm glad to report that the international arbitration community was very active in commenting and giving ideas both to the ministry and the Congress, as some changes that were not favorable for international arbitration were deleted, and we were able to comment on the other changes. So the good news is that if this bill of law passes, it's not going to hurt international arbitration. On the contrary, it has certain interpretative rules that are very favorable for what do we do.
And Juan Felipe, it would be an amendment then to the existing law. Okay.
It is an amendment. The statute will remain the same, but just a few articles will change. We also have good news from the courts. We've had good decisions in the last 18 months. I just want to mention 2 of them. The first one is an annulment decision issued in a case in September 2020, in a case called the Ruta del Sol 2. It was a very important arbitration seated in Colombia. Because it was an award rendered in, if I remember well, August 2019. And it was probably one of the first awards issued after the Odebrecht scandal. And this was an Odebrecht company that acquired the contract, as the tribunal concluded, through a bribe. So in that case, the arbitral tribunal declared the contract null and void, and the contractor attacked the award, requested a set-aside proceeding that was rejected by the Council of State in one of those decisions where they interpreted very strictly the grounds for annulment. We also had good decisions from the Supreme Court. We recently had 2 decisions that actually quoted the IBA documents. One of them was a request for recognition and enforcement of an award issued in Chile, Santiago de Chile. And the losing party attacked the recognition and enforcement, arguing that the tribunal was constituted improperly because of a conflict of interest. In that case, which is called the Tampico case, the Supreme Court quoted the IBA guidelines on conflict of interest and concluded that there was no conflict of interest in the case. And similarly, in the Sainco Ferrovial case, the Supreme Court quoted the IBA rules on taking of evidence to assess the probative value of certain documents, and that was an annulment decision and did not annul the award. Of course, we've had bad decisions. I just want to mention one of because it's very important for us in international arbitration. It's an annulment decision of the Council of State in August 2019. And in that case, it's called the Heselka case. The Council of State annulled an award because the arbitral tribunal, that was an ICC case seated in Bogota. The arbitral tribunal allowed claimant to update the damages calculation just before the hearing. And as you know, this is something that we often do in international arbitration, especially when we have complex calculations. Well, the Council of State considered that such a new opportunity to amend the expert report was against the procedural rules and decided to annul the award. So we have to be very careful in Colombia when we do these type of flexibilities in international arbitration.
Thank you very much. Colombia was actually the last country that I had visited prior to the general shutdown with respect to the pandemic. And one of the things that I noticed, and I would kind of ask for you to reflect on, was it appeared that there was a lot of attention being given to investor state claims in Colombia, and that there has been actually a fairly significant increase in those types of claims. I didn't know if you might have some comment with respect to that.
Absolutely, John. And historically, it's very important because in 2015, we were very proud to say that with Brazil, Colombia was the only country in the whole Americas that had not been sued in investment arbitration. And then a couple of years later, in 2019, Colombia was the state that received more investment arbitration cases that year, not in the region, but in the world. We were tied with Spain in the number of cases. Today, we have 16 pending cases. So there has been, as you were saying, a boom of investment arbitration. And I'm not only talking about the cases, but also in the culture. 7 years ago, no one talked about investment arbitration. And today, I'm going to say it's embedded in the legal mindset of practitioners in Colombia to know that they have recourse to investment arbitration. And there has been a lot of development in that area. Probably the good news for the country is that the results have been really good. In the last 2 years, we had 4 awards, consecutive victories for Colombia. The 5th case was an award that found the state internationally liable, but has not quantified the claims yet, and they rejected the main expropriation claim. So the state is hoping that the award is not going to be so significant, but the results have been very good for the state, although we have, as I was saying, 16 pending cases, which is a source of concern.
Okay, thank you very much. We have like about a minute left. I didn't know if there was anything that I hadn't asked you about, or that we hadn't touched that you would like to mention.
I just want to say that the pandemic was very well handled by practitioners and the government. The president issued a decree quite early in March of 2020, expressly saying that arbitrations cannot be suspended because of the pandemic, and that they had to continue using virtual means. So arbitration was a very active means of justice during the pandemic.
Okay, thank you very much for your comments. Next up will be Dayala Jiménez, who will be giving us an update with respect to the Central American region. If we could, I guess, begin with the same question in a general sense, which would be, what have been the significant developments in those jurisdictions in the region that you're going to be talking about relating to international arbitration? And at the same time, what are you seeing as future trends for arbitration in the region?
Greetings, everyone. Thank you. Thank you, MIAS, and great to see friends whom I haven't seen in a while. I thank John, thanks for the question. I'm also going to leave everyone with a happy note, which is wonderful. I think that we are seeing this for the first time in a long time in Latin America. I believe that the region has acted with resilience and adaptability during the pandemic, not only arbitration centers and practitioners, but also the judiciary. the judiciary in most countries in the region have implemented immediately virtual means to carry on with procedures and have adapted fantastic. So I think that's a general note. I will focus, John, on Guatemala and Costa Rica, just because we don't have time to do so much. And actually, we have interesting news in both jurisdictions. The first, in Guatemala, I'm sure some of you have read the interesting development regarding the TECO award. There was a payment of the part of the award that was not annulled by the ICSID ad hoc committee. And the creditor obtained the freezing of assets of Guatemala in a New York bank account in order to obtain payment for more than $37 million. And what happened earlier was something interesting, which put Guatemala in a very difficult situation. Because of the freezing of those assets, the Guatemalan government could not pay interest on Euro bonds of investors. And this in turn made the rating agencies very nervous. And the rating agencies were, putting under watch the Guatemalan government and the banks and said, we're going to, put you down in the qualification. Eventually, Guatemala paid, and the government was quite quick about it, I believe. And what they realized, even in public comments, is that even though the amount was almost the same as 25% of the increase in our budget for the health ministry to tend to the pandemic, we understood that we needed to pay, that we needed to guard our macroeconomic and our fiscal ability and balance. So that was a very interesting case of how public policy shifts in the spending priorities can allow for payment, and also how good arbitration works internationally. Besides that, I have also good news from the commercial, legislative and judiciary fronts. And not only on the legislature, there was a source of concern for many years, because Guatemala passed the UNCITRAL model law, but they adopted some minor modifications, one of which was that on a setting aside proceeding, the Court of Appeals in charge of setting aside could modify the underlying award. And while this has been used rarely, but it has been used, people are always very nervous about that. You have so much uncertainty as to whether the judiciary will change your award. Even arbitrators, become really nervous about that. So since 2014, there's a bill to modify not only that, but other minor aspects of the award. And finally, that bill had 3 readings and is now good for voting. So it should, the Guatemalan law should eliminate that aspect of the setting aside procedure. The other good news, and to finish with Guatemala, is that recently in September of last year, 2020, the Corte de Constitucionalidad, the Constitutional Court, decided that a provision in the Ley de Contrataciones, in the procurement law of the state, that allows arbitration is constitutional. So that is settled, and that is fantastic news for private parties entering into contracts with the state agencies. And moving to Costa Rica very briefly before answering your second question, John, as to what I'm seeing in the future, just 2 new cases, exit cases against Costa Rica, just as we had finished the ones that were in the pipeline. We have 2 new cases, one against the state, but against actions from the same state entity, the state-owned electric or utility entity, Instituto Costarricense de Electricidad. And there we have one under the Venezuela-Costa Rica BIT or BIT, because of the non-renewal of a contract for distribution of mobile cell phones in the country. And that is Hernandez Contreras against Costa Rica, or VNet is the name of the company. That had just been logged in by before the exit. The second is a bigger complaint against Costa Rica by a Chilean firm, ESA and Enel Power, under the Chile-Costa Rica bid, because of the non-renewal of a hydro power plant project. And there is a claim for denial of justice as well regarding another project. This was publicized, actually, the second part of the claim, but the underlying dispute has to do with this hydroelectric power. So it's interesting because it's two different projects under the same case. And I think, and I'm afraid that since that utility company has adopted a policy of non-renewables, of not to renew non-renewable agreements with private companies, and also not to allow them to produce or generate energy for export, I'm afraid there will be more cases coming up. And just to close, I'm not sure if I have more time, but John, you asked me what I see in the future. And I think just like Klaus, in Costa Rica, we have not yet seen, a surge of cases from the pandemic. In Guatemala, one center has already increased its caseload by 30%, due mostly to, contracts being not being breached by the pandemic, by restrictions. Mm-hmm. And this is what I see. I see two potential surges of cases. One, just private, contracts that are being affected, or even contracts with the state that are being affected by the pandemic generally, but also measures that the states have taken, that governments have adopted, that can be, be used as complaints by companies. In Costa Rica, we don't have, the situation we have in Peru, where the tolls were frozen for a while, and we don't have that many concession agreements. The state-owned utilities or entities are still involved in the economy. But I do see that as a possibility of pandemic effect. And the other is the container crisis. Wow. We have a huge supply chain crisis in the whole world, and this will definitely affect everyone. Because that, whether force majeure can work and can be triggered is a big question. And it will depend on, not only the legal frameworks of the countries, the contracts, the insurance. And I see the container crisis as a big potential, cause for a lot of
great observation, I think, a very good observation. And that's one of those points, I think, not particular just to your region, but I think it's something obviously with worldwide implications as well.
Yeah, I think it's global, and I think the whole shipping business and the whole, antitrust, this is a huge area of the law that I'm sure will be developed thanks to the pandemic.
Okay, thank you very much for that report. I think it was very interesting and very timely. And with that, I think I can turn the microphone back to Silvia, and I think Peru is next up, I believe.
Right, let's start going south.
Yes.
Hopefully not metaphorically, but just we know that you've been involved in many cases involving the state. Of course, here's my bias again in investor state arbitration, starting with that question. But of course, some of the recent announcements and initiatives and the back and forth of the government, especially in connection with the Camisea project and the natural gas in general, has raised some eyebrows, to put it mildly. Any comments there in terms of the potential implications from an arbitration perspective?
Well, thank you, Silvia, and thank you to Mia for this opportunity. And also commenting on these issues that Yala mentioned before, the tolls frozen, no? Because maybe we can start also with that. Because of the pandemia, the Congress passed a law freezing the tolls charged by the concessionaires, the road concessionaires. But that was brought to the Constitutional Tribunal, and the Constitutional Tribunal, and that's the good news, declared that law was unconstitutional because concession contracts in Peru are, well, there is this special category of contract law that according to the Peruvian Constitution cannot be amended even by Congress, cannot be modified or changed by Congress. So this is a guarantee to contracts executed by the state that has this quality, and the Constitutional Tribunal declared that about these road contracts. So this freezing of tolls was ended. So that was a good thing, because we believe, well, that might be brought to international arbitration otherwise. So that's the good news. The bad news is, as we all know, we have a new president, we have a new administration. It is very leftist oriented. I was listening to Klaus when he was explaining the situation in Mexico, and I'm afraid that a similar situation, we must endure a similar situation in Peru. Just 1 week ago, President Castillo announced that he has announced that he will propose the Congress to pass a law either nationalizing or extending state control over the most important natural gas field investment in Peru. That's a Camisea project. That's a $6.5 billion investment. Amounts to 90% of the natural gas produced by Peru, which is also exported, no? So that was an announcement made by the president. There was a lot of debate afterwards. It seems that the government has recoiled for the time being. But I think it gives an evidence of the way the government sees or is suspicious about investment, foreign investment in natural resources, and also strategical investments such as infrastructure, and the utilities.
And Peru has always been a leader in terms of international arbitration. Almost sometimes, you could say a little bit too much when many years ago there was a reform so that every dispute involving the government would be submitted to arbitration locally, as opposed to a typical, claim before the judiciary. And I'm wondering, have there been any recent developments with respect to arbitration in general, whether in the form of, court decisions in favor or against, or legislative changes?
Well, maybe, that is something good. We have not had unfavorable decisions. On the contrary, like the case I just mentioned about the Constitutional Tribunal. And also one good thing also was that arbitration centers in Peru have been acting very fast in order to update the rules and be able to adapt to this new this new normal situation that we are facing nowadays, no? Even like the AmCham Peru Arbitration Center, and I have the honor to be a member of their court, has recently approved new regulations aimed at adopting the best international practices relating to multi-contract arbitration, multi-party arbitration, prima facie decisions. But all arbitration centers have adopted all these new virtual settings for hearings and documents and memorial submissions, and they have been widely accepted. None of them have been contested. And also, even I'm aware of, there was a judicial resolution, I think in the late 2019 that was premonitory because it declared both two things, the validity of a virtual hearing. So that's good. The court has already acknowledged the validity of, actually the courts are also holding virtual hearings right now, and declared the enforceability of a provisional measure adopted by our arbitration tribunal in a foreign arbitration, no? So on the contrary, courts have been quite respectful. And also one thing to point out is that all the changes to the arbitration rules by the arbitration centers have been made without the need to change our arbitration law. So we have an arbitration law that it's like very flexible, that gives a lot of flexibility and discretion to the arbitration centers. And I think that it's something good, no, something positive.
Absolutely. Perhaps just in 1 minute, any comments as to what the future may hold in Peru for arbitration?
Okay, in 1 minute, I'll try to do that. Peru, that's the, I don't know, the bad news, no? But Peru has been in 2021 at the top of the list of countries that have lodged cases against Peru. So right now there has been like 6 cases in year 2021 against Peru. It has 19 cases at ICSID pending, no, relating to mining, to the mining industry, relating to infrastructure, port terminals, the metro, no, roads. In my view, these conflicts will increase. I think like in Mexico, if the intents to change the constitution by these governments succeed, then we'll see a lot of arbitration, because one of their proposals is to change Article 62 of the Constitution, and Article 62 is the one that protects contracts from being amended or changed by the state. And they want to change specifically that article, so they will be able to change contracts, change tariffs, set conditions under emergency circumstances. So if that happens, of course, a lot of arbitration, we will see a lot of domestic and international arbitration. So in my view, things unfortunately are going to scale in the international arbitration arena.
Thank you, Maria Teresa. And switching gears, again, going further south, Gerardo will discuss Chile and changes. That's a good segue to focus on Chile now. We've seen the uncertainty resulting from the constitutional reform that is currently ongoing. Some measures already directly affecting the pension funds. The firm have already quite a few matters in connection with that. Should we start there as our first stop in Chile?
Yes. Thank you so much, Silvia, and thank you so much to MIAS for this invitation. Well, we are in the same side that Mexico and Peru in connection with investor-state disputes. They have increased for sure in Chile. During its time at ICSID, Chile had only 5 cases, just 5 cases, in one of which, by the way, panelist Klaus Von Vovisser was the president of the arbitral tribunal. But going back to your question, we're talking about 5 cases, and during 2021, however, 2 requests for arbitrations were filed against Chile at ICSID, 2 requests for arbitration. One of them relates to the construction of a transmission line, and the other one relates to the construction of new buildings for the Santiago International Airport. But in addition, and this is very important, and here I go with your question, is we should be note that the Chilean Congress, they amended the constitution, invoking the need to mitigate the economic effects of the pandemic. And they allow the withdrawal of pension funds including, and this is crucial, the ones held by the insurance company due to life annuity contracts. So, an international insurance company established in Chile, like Zurich, MetLife, Principal, and Ohio, consider that these laws, this amendment of the Constitution, affected the rights under the existing BITs, and therefore during 2021, they requested the commencement of 4 consultation process with Chile. Therefore, it is possible that that we, in the coming years, we will have 4 new investment treaty arbitration cases. So, as you can see, the numbers are increasing significantly in Chile.
And how about Chile, and more specifically Santiago as a seat? It is quite an active jurisdiction. Many, even from a investor state perspective, many states in the region a few years ago were accepting UNCITRAL rules and Chile as a seat. Any developments in terms of the case law?
Yes, I am very optimistic about the future of international arbitration proceedings in Chile. Chile has a long-standing tradition regarding international commercial arbitration, and our local courts have never annulled any international arbitration award. And this is quite similar of what happened in Peru. I would like to point out that that there is a very ambitious project in Chile. It is a project by the Chilean Construction Chamber and the Arbitration Center of the Santiago Chamber of Commerce. We are talking about the most important construction chamber and the most important arbitration center, in order to resolve through arbitration all the disputes that are held between the Ministry of Public Works and building companies. So that would be a very, very important step. We will be in a much better position if all those contracts has their arbitration clauses. I am optimistic about the future. And in addition, I would like to point out that that I believe that the development of the arbitration in Chile is going to be very, very important, because as we all know, arbitration centers, they find their way to continue with the proceedings, but that was not the case of what happened with the Chilean ordinary courts. Ordinary courts has now a huge delay, because all the terms, all the evidence terms were suspended by law for 16 months. So now the delay is very important, and the restart process is having many complications. So I believe that this will cause this comparison between what happened with the arbitration proceedings and what happened with the civil courts will make lawyers and companies to opt for arbitration clauses in all the new contracts. So I believe that the development that this would make in the Chilean arbitration file, both domestic and international, is going to be very, very important.
Absolutely. Perhaps before we go on to Brazil, we do have a question in the chat for Klaus. Klaus, Chris Garvey asks you, can you comment on the climate for enforcement of investor state arbitrations in Mexico and any recent trends? That is Mexico complying with its obligations when it loses?
Mexico traditionally has honored all the awards. There have not been, as far as I know, recent decisions with the new government in the last 3 years, or at least that I know, that have not been honored. But traditionally, Mexico has paid all the awards it lost, and that was a policy of the prior government. We have not had a case yet. I suspect that probably Lopez Obrador would not honor. And we have had Pemex and CFE not honoring awards, and we have been successful. I've been representing clients that have collected awards in New York, of course, with colleagues from New York litigating the case before the courts in New York. But so traditionally Mexico has paid, but the federal government has paid automatically well, and the entities such as Pemex and CFE have often awards have been enforced outside of Mexico. But I suspect that this government probably would not honor awards, and so we'll see what happens going forward. But so far we have not had a case. Thank you. Thank you for the question. Thank you, Silvia.
Of course. John, last
Yes.
stop.
Thank you. Last but not least, the largest country in the region, Brazil. Cristiano Zanetti is going to be bringing us up to date with respect to developments. He was kind enough to circulate in advance to the panelists and organizers some points that he considered to be important, and I'm going to ask him to develop those. One of them, what I understand, is that there is the possibility of an amendment to the Brazilian arbitration law. And if my understanding is correct, Cristiano, if you could give us just an overview of what that would portend if it in fact came into effect, and what the probability of it being enacted would be.
Thank you, John, for inviting me to participate at this event in Miami International Arbitration Society. We're never bored in Brazil in terms of legislative bills. There's almost every time something happening, and arbitration has been sometimes under attack by congressmen and congresswomen, and this is another attack without any good reason. This is a project, we have learned about this project very recently, a month ago, and it comes from an otherwise unknown politician who has no ties with the arbitration community. And it has two rules that has our eyebrows rose immediately. Because it says that no arbitrator can afford more than 10 cases at the same time, and it will not be allowed for arbitrators to sit in different tribunals with the same people, meaning every arbitral tribunal must be entirely different. If you have one person working with another, this could only happen in one single arbitral tribunal.
Cristiano, how would that be enforced in an international sense?
We don't know that yet. It's a project, it's very badly written.
Okay.
But it could create a lot of trouble because there's obviously has been a lot of opposition against this bill. And the Brazilian Committee of Arbitration has already sent a note and is trying to meet this congressman to show that this is completely absurd, that all other entities are against this project. So I don't think it will pass, but we have to be careful. We don't know what happens in our countries. Latin America is sometimes an unstable region, and this is a complete disaster. We don't know what would be the effects regarding international arbitration, but we want to make sure that this one will not pass. We have been handled this kind of situations for quite some time now, and I'm confident that this one will not pass, but it's obviously a major reason for concern. I think that everybody would try to avoid applying Brazilian law, at least regarding the procedure. If this bill passes, that would be very bad for the country. If you think about the ambition of Brazil becoming a more international center of arbitration. So this is the bad news, but I think I had some good news as well. So.
Okay. But before moving to that point, the other thing I guess would be the issue that you raised was one of confidentiality in arbitration, which is not necessarily an issue that would be front and center in the other jurisdictions, and one I think that is not subject so much to attention, but it has gotten some recent attention in Brazil, I guess, right?
Yes. This bill very confused, we would say, but it tries to make arbitration more public. We cannot understand exactly how, but besides that, there has been a couple of decisions of state courts, no decisions yet from the federal court, which is the highest court in these matters, saying that any action regarding arbitration in state courts should be public, regardless of the nature, regardless whether there is a confidentiality clause or not. This is directly against our civil procedure code, which states that arbitration could be confidential if the parties want to. But these decisions, they understood that such provision of the Brazilian civil procedure code is against the constitution. This is a very, very disputed issue in the community, but in fact, some cases has already been disclosed because they have decided so. It's okay, it must be public, so everybody is aware of some cases that should be confidential. That caused major concern in the arbitration community as well. And then what happened is that people are considering very strongly to use more arbitration, the emergency procedure arbitration, emergency arbitrators, I mean, because they do not want to share their information, especially at the beginning of cases. So sometimes they do not mind to share the outcome, although they're not enthusiastic of that, but to share information at the beginning of a case, to share information that a dispute is beginning between A and B. This is bad news for private entities, and sometimes for the state as well. So what people are considering very, very strongly these days is to use emergency arbitrators, which is allowed for the ICC, as everybody knows, but also for other Brazilian arbitration institutions.
Okay, excellent. And then moving on, I guess, to what you said was also the good news, if you'd like to.
Well, I have to share some good news. I'm the last one speaking, so I do not to end in a low note. I want to keep it a high note. So these are, I would say, problems that we're facing right now, but I think they're minor problems, and I think we'll overcome both of them. I do not think that this bill will pass. I would be very surprised if it would. And I think this line of reasoning stating that all arbitrations must be public while in judicial courts is wrong, and I think will not prevail. But what is important, and sometimes not very clear from the beginning, is that Brazil has no BITs. We don't have to sign ever any BIT. So people may think that Brazilian state entities are not in arbitration. They prefer judicial courts, and that's not the case. Since 2015, state entities have participated more and more of arbitration proceedings, and currently in the main three chambers alone, there are 88 arbitration proceedings involving state entities. And not only we have, I think, an important number of cases involving state entities, but the value of those cases is remarkable. I do not have the whole figures, and this is just a rough number that I received in my research, but in the ICC alone, we have disputes concerning the state that amount to $7.8 billion US. So this is a huge player that is enforcing arbitration very, very strongly. They contrary to what some people expect, the state is not only using arbitration, but they really are using it consciously and very, very optimistic about this way of solving their problems. So this is a huge difference from what we have some years ago. I was sitting in the first case that the union, which represents the whole country, participated, and was all new, and it ended in 2019. It was like in the Middle Ages. It's just a couple of years ago, and it was the only case. And now we have 88, and the numbers are important. The public lawyers are well prepared. So this is a trend that has been confirmed, and I think this is very relevant because although we do not have a BIT, we do have a lot of disputes with the states from one side and private investors from the other side, and that has been running smoothly. And I think this is a trend that we confirm in the near future. We probably will have more cases in the future, I think.
Perfect. Well, Cristiano, you landed the plane exactly on time. So
yeah, I tried to.
You did. so thank you very much for your presentation, and that brings us to the end of the reports, the 6 reports that constitute the program. And I guess that Adolfo might have some words of close for us, right?
So I think we've covered the questions that were posed. I first and foremost want to thank the panelists
Yes.
for these excellent updates that you each provided. It's been a really wonderful overview of the situation in Latin America. I want to thank the moderators who put a lot of work into organizing and putting this together and getting a great group of people who have provided a lot of valuable information. We're leaving here with a good sense of what the state of international arbitration is in Latin America. I find it very, very dangerous to suggest that you can generalize the region. It's a very diverse region, but what struck me from these presentations is there's a fair amount of commonality from country to country. We're seeing a lot of pressure and tension coming towards the energy sector and in particular the utilities. We're seeing in most jurisdictions an increase in constitutional changes or reform or legislative changes that seems to be affecting each of the countries and regions that we were with. I'm struck by the fact that generally the reports, what I might take away anyway, is that courts are coming a long way towards being positive and supporting international arbitration for the most part from country to country. And so it's a lot of takeaways from this program. You each provided so much valuable information. Fortunately, the program is recorded and will be posted on the MIAS website. It's mias.org. So it should be posted in just a few days. It's I know that from my vantage point, it's just a very good way of getting solid update and information in just 60 minutes. And so thank you again. Thank you for all of you who attended. This has been very, very valuable and we really appreciate your participation. Have a good day.